All right, let's jump straight into this deep dive on the 1999 South African Constitutional Court case, CCT 9099. We're looking at a truly pivotal moment in history where a very young, vibrant democracy had to make some incredibly tough choices about its electoral laws, right ahead of its second ever national democratic election. And honestly, the core of this battle, figuring out how to guarantee election security without accidentally locking people out of the ballot box, is a universal struggle. It's something democracies across the globe are still wrestling with today. So how exactly do you balance bulletproof election security with the fundamental right to vote? That's the beating heart of our analysis today. Picture South Africa in 1999. The country is gearing up for its first election since the historic 1994 vote. And the stakes? Well, they literally could not be higher. On one hand, you have the absolute necessity to enfranchise millions of people. But on the other hand, you have the strict constitutional demand to prevent fraud and ensure the election is entirely credible. How you possibly balance those two immense pressures? To unpack all this, we'll be following a quick roadmap. First, the 1999 election challenge itself. Then we'll hit the barcoded ID debate, move into rationality versus denial, check out the role of the independent Electoral Commission, and finally wrap up with the dissenting view. Part 1, the 1999 election challenge and the incredible stakes of South Africa's second democratic election. So the whole thing kicks off with the new National Party challenging the Electoral Act. They were arguing that strict new ID requirements plus government interference were basically threatening the 99 elections. But the court had to look at the big picture, the constitutional mandate to create the very first national common voters roll. They made the point that the right to vote is, well, pretty much empty without proper regulations. If you don't have a reliable voters roll, you simply can't guarantee a free and fair election where everyone votes just once. So setting up these rules wasn't actually seen as restricting the vote, but rather as a strict constitutional must-have. Moving on to Part 2, the barcoded ID debate. Let's look at the actual numbers behind these ID requirements. To really get a sense of this, we have to look at the sheer scale of the issue. Out of roughly 25 million eligible voters, about 20 million, so 80%, already had the required green barcoded ID. But the real crisis was happening in the margins. You had 2.5 million people with absolutely zero ID and another 2.5 million carrying much older forms of identification. And this was a huge deal because the new Electoral Act mandated that only the barcoded ID or a specific temporary registration certificate could actually be used to register and vote. You might be wondering, why is such a strict requirement? Well, the court drew a really stark comparison here. The old identity documents, stuff like reference books and passes, were essentially powerful, painful symbols of a shameful history of racial discrimination. They were literally issued based on race. In sharp contrast, these new barcoded IDs were totally uniform for all citizens. Plus, they required fingerprints to be logged on the National Population Register, and that barcode meant verification was incredibly quick and reliable. So, for the court's majority, enforcing a single, secure, non-racial document was just an absolutely essential step forward. Part 3, rationality versus denial. Here, we'll look at Justice Yacoob's legal test. To figure out if this super strict ID law was actually unconstitutional, the court used this critical two-pronged legal test. Step 1 asks a simple but really powerful question. Is the law rationally connected to a legitimate government purpose? Basically, this stops lawmakers from just acting arbitrarily. Step 2 looks at the real-world outcome. Does the actual machinery of the law deny citizens the right to vote, assuming those citizens are acting reasonably to try and vote? When they applied Step 1, the law passed pretty easily. Think about it. A single, secure, barcoded document directly prevents electoral fraud. It uses those recorded fingerprints to stop double voting dead in its tracks, and it lets election officials seamlessly verify voters. That completely avoids the total chaos of trying to check dozens of different, confusing document types on election day. So boom, it passes Step 1. But Step 2 is where it gets tricky. Did it actually deny the right to vote? The applicants argued that the Department of Home Affairs simply didn't have the capacity to issue 5 million IDs in time, which would effectively disenfranchise millions. But the court made a really vital legal distinction here. They said, look, a law isn't unconstitutional just because the agency implementing it is struggling with capacity. The law itself gave citizens a clear mechanism. You could apply for the ID and get a temporary certificate within 24 hours to go register. If Home Affairs ended up with massive backlogs later, well, that's an implementation failure. That can be challenged separately, but it doesn't make the actual statute unconstitutional. Okay, Part 4, the Independent Electoral Commission, focusing on funding and autonomy. This part shifts our focus away from the voters and the IDs and looks right at the institutional autonomy of the Electoral Commission itself. See, the Constitution created the Commission to be this fiercely independent body meant to manage elections. Deputy President Longa really hammered this home in his judgment, stating the Commission must act subject only to the Constitution and the law, meaning they have to operate without fear, favor, or prejudice, completely detached from executive government control. They answer to the National Assembly, not to some government minister. But out in the real world, things were getting incredibly tense. The Departments of Home Affairs and State Expenditure kept treating this independent commission as if it were just a standard, run-of-the-mill government department. They even tried to use Treasury Instruction K5, which is this rule that would basically let a government accounting officer evaluate and potentially choke off the commission's funding. And on top of all that, the government severely delayed approving the commission's staffing regulations. So, the big question. Did the government act unconstitutionally here? Ultimately, the court ruled no. But the reason why is fascinating. It's because the commission didn't break. When the government applied all this pressure, the chairperson actively fought back. They asserted their independence and actually found creative negotiated solutions, like getting civil servants seconded to help with registration when the budget was super tight. Because the commission stood its ground and didn't capitulate, the court ruled that its independence hadn't ultimately been compromised. Finally, Part 5, the dissenting view. Let's look at Justice O'Regan's perspective. To really grasp the full weight of this case, we have to look impartially at a highly compelling dissenting opinion. Justice O'Regan's entire argument hinges on this concept of positive obligation. While a lot of constitutional rights just require the government to leave you alone, she argued that the right to vote is different. It requires the state to take active, positive steps to fulfill it. Basically, the government carries this immense burden to make sure the electoral scheme is entirely reasonable and flexible enough that citizens can easily exercise their franchise. Building on that idea of positive obligation, she pointed right at those 2.5 million people holding old IDs. And her point was actually brilliant in its simplicity. She noted that the government still legally validated those old IDs for banking, signing contracts, you name it, everyday life. So to suddenly turn around and ban them exclusively for voting, that created an unreasonable barrier. She concluded that the electoral scheme lacked the necessary flexibility and that shutting out those otherwise valid documents put a totally unconstitutional burden on millions of voters. It's a really powerful debate, isn't it? And it leaves us wrestling with this fragile, ongoing challenge. What kind of continuous effort is really required to maintain a free, fair, and credible election in an emerging democracy? Finding that perfect balance between airtight security and absolute voter enfranchisement isn't just a math problem you solve once and forget about. The 1999 South African election challenge shows us that the health of any democracy demands constant vigilance, fierce debate, and a deep, unwavering commitment to both the integrity of the ballot and the right of every single citizen to cast it.